Well, thank you everyone for joining us. Today's session is How to Be an Effective Advocate, a View from the Bench, where we have a panel of judges share about their experiences, suggestions for new attorneys, and just discuss how to be an effective advocate and the role that attorneys play in addressing the access to justice gap. I have some questions that folks submitted ahead of time. I also encourage you to use the chat feature to answer questions. And basically my plan is for around 12:30. I'm just gonna switch and turn to questions asked by you all, either in the chat or if it's an appropriate time and you wanna unmute yourself and video to ask your question. I think that might work as well. As I say that a little reluctantly to a group of 50 or so, but I think that we can make that work. But I want, we all want to hear from you and get the questions that you want answered. So come up with some questions, use the chat, unmute yourself, and we'll go from there. So just to give a little bit of background on our three judges. First, we have Judge Edmond Chang, who in December of 2010 was unanimously confirmed by the Senate as a U.S. District Judge for the Northern District of Illinois. When he began his service in early January 2011, he was the youngest federal judge in the nation, as well as the first Asian Pacific American Article III federal judge in Illinois and in any state of the Seventh Circuit. Before taking the bench, Judge Chang served as an assistant U.S. attorney, serving as Deputy Chief of General Crimes, as well as Chief of Appeals of the Criminal Division. And before that, Judge Chang practiced employment and labor law at Sidley Austin, where he was a Pilley Fellow at Chicago-Kent College of Law Legal Clinic. We also have Judge Alison Conlon, who presides at the Daly Center, hearing civil cases in the Chancellery Division. Before becoming a judge, Judge Conlon was a partner in the law firm of Barnes & Thornburg, where she represented people, businesses, cities, and villages in commercial and tort litigation. Before that, she was an assistant corporate counsel for the city of Chicago and a law clerk for Judge Charles Kokaras. And Judge Conlon is also a Pilley board member. And then we have Judge Katherine Schneider, who's currently a Cook County judge presiding over civil jury cases. She worked for over 21 years as a public interest attorney, most recently as a supervisor of the Carpels Legal Aid Municipal Court Advice Desk before becoming a judge. She was also previously appointed by the Illinois Supreme Court Commission on Access to Justice as a co-chair of the Forms Committee, where she was charged with creating statewide user-friendly court forms for pro se litigants. And she was also co-chair of the Women's Bar Association's Access to Justice Committee. So excited to have all three of you here with us. And so I briefly kind of touched on how you each became a judge. Since there are different paths to the bench, and to give a little bit more perspective as we have this conversation, can you each describe a little bit more about your background and how you came to the bench? Maybe we'll go in that same order to start. If Judge Chang, you want to start first?
Yeah, sure. Well, as Brent mentioned, my first job out of law school was actually to be a Pilley Fellow. So for those of you who are fellows, I was sitting exactly where you were at the time. And it was at Chicago-Kent's legal clinic doing criminal defense work. That was an amazing experience. That, as well as some other externships, including at the Lawyers Committee for Civil Rights Under Law, really impressed on me that at some point I wanted to make public service my kind of full-time job going forward. But I had at least 4 years of my life planned out at that point going forward, because I had already agreed to clerk for a couple of federal judges, and one of them for a 2-year clerkship. So that was 3 years of clerking. And then I had committed to, of course, since they paid for my Pilley Fellowship, spend at least a year at Sidley Austin, where I practiced labor and employment law. And then I joined the U.S. Attorney's Office, and I spent around 11 years there before being nominated by President Obama. But I will say that I actually tried twice to become a federal judge. And the first time I was actually a finalist during the last year of President Bush II's, his last term and last year in office. because I'm actually not a member of either political party. I've just not ever been, kind of partisan aligned in one way or the other. And so I actually did not, I was one of the 3 finalists, went to the White House to interview, did not get the nomination in 2008. But after President Obama was elected, I tried again, and this time was nominated. So next January will be 10 years on the bench. So that's the path.
Great. Judge Conlon?
Okay. So I was in private practice. Well, I started clerking for Judge Kokoris, a colleague of Judge Chang's in the Federal District Court. And that certainly piqued my interest in becoming a judge someday. That was a really excellent experience in court and behind the scenes working with him and his staff on cases. Then I went to the city for a time and did constitutional and commercial litigation, and then I went into the private sector until I became a judge. While I was in the private sector, in addition to doing my regular job, I did try to become involved in the Chicago Bar Association, which introduced me to a lot of people that I wouldn't otherwise have met with the type of work that I was doing. I got involved with the Chicago Bar Foundation. I partnered with some organizations on pro bono initiatives who honestly knew more than I did about the subject matter and could create a great platform for me to work off of from the private sector. So those partnerships are great. And then after I had enough years where I thought the bar associations would be receptive to evaluating me in a positive way, I started working on trying to become a state court judge. And there are a number of ways to do it, as Brent alluded to, but the pathway for me turned out to be applying to be appointed by the Supreme Court when a vacancy came up, when a judge who had a 6-year term retired before those 6 years ended. So I became a sitting judge in February of 2015 by appointment in the circuit court. And then I ran for office countywide and fortunately won the election, the primary, in March of 2016. And so I've been on the bench just over 5 years through an appointed, then elected pathway.
Judge Schneider?
Hi. First, I want to say thanks for inviting me. I'm so pleased to be here, especially with Judges Conlon and Chang. So I started in private practice as well. I was doing some insurance defense work for a small firm, doing work for State Farm. And I had sort of a varied career in private practice. I did some landlord-tenant work. I did some work for some small businesses. I did some real estate transactions. And then I moved into public interest. I worked for the Lawyers Committee for Better Housing a while as their pro bono coordinator, and then ended up eventually at Carpels, where I worked for over 10 years, managing the help desk at the Daily Center. So we provided free legal advice and guidance and help people with forms at the Daily Center. And these were folks who had to go to court in First Municipal. So they had issues like they were facing evictions and collections. At Carpels, we had other self-help desks at the Daily Center that help people with family matters. But I was managing the First Municipal help desk. And during the course of that, my family encouraged me, after all of my comments about how much I thought I would enjoy being on the bench, they encouraged me to run for public office. So I just started a campaign. I really ran sort of a grassroots campaign. I live in Oak Park, and I ran in the sub-circuit when there was an opening. So I threw my hat in the ring. There were 2 other people in the race, and we worked really hard. And fortunately for me, we won the primary. So it was really exciting, and I was sworn in December of 2016, same time Judge Conlon was. So I've been on the bench since then. So what is that? A little over 3.5 years now, and it's just been marvelous. What a great honor.
So PILI's mission is to engage, inspire, and empower those advancing equal access to justice. And all of our interns and fellows are, doing that at their agencies this summer. Can you share a little bit from your perspective on the responsibility placed on lawyers to provide public service, why it's important for our community, and kind of what experience you've had or any experiences that you've had that really exemplify that? Judge Schneider, maybe we'll go to you first and then kind of go in opposite order.
Sure. So ideally, I think that justice is a universal good, and the law protects equally the rights of everyone, the rich and the poor. And at a minimum, justice means the ability to bring a claim to court and defend yourself in court, but in reality, access to justice can mean so much more. And you have to be able to navigate giant bureaucracies in government, fill out forms, and plan for major life events. Lawyers hold the keys to being able to navigate those mazes. And what I've learned in my career is that the legal issues don't discriminate. All of our neighbors face difficult legal issues and legal issues that affect their day-to-day lives. Adopting a child, divorcing a spouse, facing a collection. So as lawyers, I think that we have a responsibility to make sure that everyone in our community has access to getting through that maze and figuring out how to handle their legal problems. And I think it's part of being a lawyer, is using those skills to help your community.
Great. Judge Conlon?
Thank you, Judge Schneider. I agree with so much to all of what she said. I think there is a special responsibility. I think much of the time it's also a special joy when you can bring the privilege that a law license confers, and it is a privilege. I mean, you see it the minute you step into a courthouse. At least in our courthouse, lawyers get to go through a different line than non-lawyers do. And that privilege extends as you travel through the courthouse. And it is a privilege that is meant to be shared. I know that with the number of self-represented people that I've seen, and as a new state court judge, you see a lot of self-represented people. And it's one thing to read statistics, which are compelling. It's another thing to sit and really watch people try to navigate. And you do see on an almost daily basis, especially as a case gets closer to trial, how somebody who's not knowledgeable in the law may just not be able to put on a case for themselves, especially if the opponent is a lawyer. I did have pretty good success with cases where no lawyer was involved and everybody was self-represented. I actually think people can do an amazing job of representing themselves if they're given a fair process and an opportunity where they can be heard. And that's harder to do than it sounds with court volumes and all the other pressures that come to bear. But when you get a situation, especially where one side has a lawyer and another doesn't, it's a barrier, I think, to finding the truth. And, that was one of many good reasons why we all became lawyers, to help figure out what the truth is, make sure that people get a fair shake, everybody gets to get heard. So I'm hoping that not only is there an important responsibility placed there because of the privilege of the license, but there's also an accompanying joy that comes with it.
Judge Chang?
Yeah, it was very well said, of course, by Judge Conlon and Judge Schneider, and I agree with all those points. I mean, our mission, which we believe in fervently, is to provide equal justice under law. Can't do that if there's no access to justice. And so, as both of my colleagues have said, the imbalance in the ability to litigate a case between someone who's represented and someone who's not is just stark. And it's even at the very beginning, like service of process. it's not that easy to figure out like how to serve process sometimes. And if you don't have the funds for it to hire someone, and you're trying to do it on your own, it's extremely difficult. That is the first step, in litigation. And then of course it just gets more and more complicated from there, in terms of both the substance and the procedure. So lawyers, we really are privileged. It's a license. The state gives this privilege to only those, few of us, and so it is something that we ought to take as a responsibility, because it's just exceptionally difficult for a pro se litigant to navigate the system.
Judge, will you also, Judge Chang, talk a little bit about the impact of your Pilley Fellowship, personally or professionally?
Yeah, sure. I mean, it had impact, of course, on both. I mean, in the criminal defense clinic, you really learn how solemn a responsibility it is to represent a client who has, their very liberties at stake. And that really impresses on you how important it is to put all the work, that is needed. So really, I think, enhances your work ethic when you have a public interest experience like this, because the stakes are so high. At the same time, you learn, and I drew many lessons from just the client relationship building. There is a very fine line between, of course, doing more than just the traditional lawyering, in court. And you are at sometimes, very much a counselor, and in some ways a very personal counselor to your clients. But you still have to keep a professional distance, or else you lose your effectiveness as an advocate. And so I learned a lot of lessons from that, because you don't get a lot of experiences like that in law school to learn client relationship building. And then just professionally going beyond that too is the attorney for whom I worked, Mark Kadish, became a lifelong mentor. We kept in touch throughout the year, throughout the years, and he was a mentor, throughout the entire process, including the judicial nomination process. He actually was a voice that had weight with the White House, and then I had the privilege of recruiting him to be a pro bono lawyer when I was on the bench 2 times, and like exceptionally difficult cases, and I just called on him directly. So it kind of came full circle. And of course, he brought along associates to do a marvelous job on the case. But it's not just the lifelong commitment to public interest, which of course is the primary mission of Pilley, but you do build these mentoring relationships that also last a lifetime.
So the group that's here with us today, are law students or recent graduates. Not many of us have so much experience stepping up in court or delivering oral arguments in front of the judge. What advice do you have for this group of new attorneys or soon to be new attorneys? What tips do you have for them, both for their career, but let's say like stepping up in front of the in court for the first time? What would you say to them as they're about to do that? And maybe it's over Zoom this year, but Judge Schneider, maybe we go to you and then go down as we have been.
Sure. So if you can, it might be really helpful to observe that judge before you go step up before that judge and present your first argument. So you kind of get an idea of that judge's demeanor. We're all people and we're all different, and we all interact with other people in different ways. So it might be a good idea to have to understand what the judge's demeanor is and get an idea of what the judge expects during the call. And I think it's also important to understand the judge's standing order. Some judges have them, some don't. And if the judge does, you might want to read that. So you also know what to expect from beginning to end. There are many clues in there about notices beforehand and maybe length of time parties might get for argument and how to enter orders. So probably the bottom line would be preparedness. It's really nerve-wracking the first time that you appear before a judge and have to speak up. You think about Am I going to say the right thing? Am I going to make a mistake? One thing that one of my mentor as a new lawyer told me that really helped a lot is he said, you know, you're going to be prepared, but don't worry. If you mess something up, we can always file a motion. And I thought that was good advice. You know, he knew that inevitably I would make a mistake, but there would be a way that we could fix it. So I knew, at least in the back of my mind, going in as prepared as I could, if I messed something up, I knew I'd have help fixing it. So that helped to calm me down.
Thanks. Judge Conlon?
Sure, all good advice. Yeah, in addition to what Judge Schneider suggests, I think asking the judge directly, Judge, I've never had this kind of proceeding in front of you before. How do you prefer to do it? I like that. I had a lot of experience in my prior assignment with Judge Schneider in First Municipal in doing jury trials with very young lawyers who were cutting their teeth. They were terrific, usually 1 to 2 day trials. And to be honest, I was cutting my teeth too as a judge. We were all learning this together. It was really kind of rewarding. And a number of you'd sometimes see a newer lawyer try to pretend that they didn't have to ask any questions, and that's okay to keep a game face, especially maybe for your opponent. But I found it refreshing when people said, I've never done this before. And sometimes in the back of my mind, I was thinking, I haven't either. So let's see how this goes, right? So I think questions are good. Another plug, both of my colleagues have already mentioned mentorship. And in terms of what you can do outside the courtroom to prepare, you know, a lot of you may be pursuing things that are in smaller environments. I talked to folks from the CBF, they're justice entrepreneurs who are going out on their own to do really inventive things. And that's terrific. But I always tell them, you know, be sure to talk to people ahead of you. And one of the benefits of being a new lawyer going to court is that the people ahead of you all remember their experiences doing it. And it's something that I bet a lot of people want to give advice about. So I would encourage you, in addition to, you know, doing your research within the courtroom with the judge and the standing order and observations and asking questions, to always have somebody a little ahead of you who's done a little more than you have, maybe a lot ahead of you, to whom you can direct your questions, small, medium, and large, about how to conduct yourself in front of a particular judge or in a general way.
Great. Judge Chang?
Yeah, sure. If it's a full-blown oral argument, I think it's really useful to actually mooch the argument ahead of time, if you have the time and resources. And I completely understand if you don't always have the time and resources to do that. You know, I can't imagine at the criminal defense clinic actually being able to have the time to juggle that in there. But if you do have the ability to do that, it's certainly worth doing. And it's kind of easy to say moot court, and then it devolves into like a discussion. So it is actually important, I think, to have, if you're going to moot an argument, to stay in character and to tell your the lawyers whom you've drafted into this duty to, you know, please stay in character, because otherwise it does kind of slip into, yeah, how am I going to handle that question? And then you start, you know, talking it out, and you're no longer mooting the argument. And it also gives you a better sense of time management. If you've got a time limit on your oral argument, as most appellate courts do, and some trial judges as well, that if you stay in character, you'll get a sense of, you know, do I really have the timing down right? The other point I think is, and Judge Conlon alluded to this, is it's just candor. It's very important. I just want to know the honest answer. And if the honest answer is, I don't know, I infinitely prefer that than, you know, to a lawyer trying to, you know, kind of bluff their way through it. And if you don't know where that particular fact is in the record, then you say, I don't know, but, you know, Your Honor, after the hearing, I'd be happy to go through the record and then supply, you know, post-argument, either brief or a letter, or however you get that back in front of the judge. It's just so much better to have that candor, and I respect it when someone doesn't know the answer and says they don't know the answer. It gives me, that lawyer, so much more credibility. And then the last thing I'll point out is for those of you who are Philly fellows and making your way to big law next, it can be difficult to get in-court experience, and you can understand it somewhat, from the client's perspective. They might have some concern if they're giving, like a first or second year associate the argument, on a summary judgment motion, something as momentous as that. But there are judges who have standing orders, and I'm one of them, and I think more judges are doing this, which encourage clients and partners to give newer attorneys experience in presenting argument in court. And it's very explicit in the standing order that, look, you can parachute in at any time, right? Because I think some lawyers are concerned that some partners and clients are concerned that if the lawyer messes up somehow, most judges like, one lawyer to talk, for, that one motion. But I have no problem if it's a witness exam. You can just come on up to the lectern, and continue the examination. If the end result is giving more experience to newer lawyers, so you might look for that, and then talk to the partners on the case about maybe getting experience under that kind of rubric. And it may be not even arguing the entire motion, but pieces of it. Because I've started to see this too, where the lawyer will say, well, Your Honor, on this issue, we have this lawyer to present, and then I'll, argue the rest of it. And that's perfectly fine. Again, if the whole point is to get a newer lawyer more experience.
Great. So we have our first question from one of our interns, Shanti Parrish from Cabrini Green. Do you want to ask?
Oh, hello. Yes. I had a question. I want to know, how as new attorneys, do we approach speaking up during times like this when minorities are fighting for equality without facing backlash from future employers?
Okay. Someone want to tackle that first?
Yeah, I mean, that's a great question. I'm going to half dodge it in this way. So, in the court, we, obviously there are judicial codes of conduct that apply to us judges. And then actually there's a very robust, some would say, too robust code of conduct that applies to judicial employees, including our law clerks. And that has been a struggle recently. And that's because there's a canon in the code of conduct that says that employees, including law clerks, cannot engage in either partisan activity. Okay, that's easy, particular political candidate or a referendum, but also nonpartisan political activity. And there is a debate going on, and I can't reveal much about the internal deliberations about what really is political these days. And in some ways, I think it's unfortunate that so much has been swept into that term that we're restricting what our newer attorneys, our law clerks, can do. Now, I hasten to add that again, from the judge's perspective, we have nothing but our credibility. We can't print money, so we have to go to Congress for funding. Right, that's on purpose. We have no power of the purse. We have no power over the sword. We have 0 executive officers, and all the officers you see in court, they're from the executive branch. So, as Alexander Hamilton designed it, we have power neither over purse nor sword. So our credibility is everything we have. So that is what we are, manic, absolutely obsessed about. Our not just independence and the perception of fairness, but also the actual fairness, and so that is why we do take this very some would say extreme view, but it makes it really difficult. I do think you're starting to see examples of newer attorneys in big law speaking out, and also that the heads of these law firms speaking out. And so I think it's becoming less controversial. But I hasten to add that as a judge who has not been in big law for 15 years or so. I don't want to pretend as if I know exactly what the industry is thinking. I see little signs of it opening up, but I'm afraid that's kind of the best answer I can give you.
Great, thank you for that.
Judge Conlon or Judge Schneider?
Yeah,
Anything to add?
Sure. I mean, I think that's an excellent question, an important question, an excellent answer and explanation of where we come from as judges. At times like this, I kind of become envious of the lawyers who do have a lot more latitude to speak up and say what's on their mind, and young people who are becoming lawyers and so forth. And I do think, I mean, I did a lot of recruiting for my law firms, but this was, as of 5 years ago, which also is not current. At the time, kind of the biggest kerfuffle we would have is if, there was something on Facebook that wasn't political, but sometimes employers look at that, not saying that I had a lot of direct involvement in that, but that was sort of the biggest thing that we could warn our younger people against. This has a totally different dimension. It seems like the dialogues we're having now are just critical. And as long as somebody is, if you're saying something that you truly feel and you're putting something behind it that's out there, maybe I'm being too optimistic and idealistic, but if any future employer had a problem with that, so be it, right? I mean, so be it. I think that the dialogue is so important that I hope future employees are not compromising, saying what they need to say, and also understanding that our views are going to be honed and changed while we all work through this together. And that's a good thing for all of us. So I wish I had a concrete answer for you about kind of how to navigate this. I'm going to say, and maybe it'll increase my credibility with Judge Chang, I don't know the answer, right? But you're asking a vital question, and I really hope that people keep expressing themselves, especially people who are newer in our industry, so to speak. We really need that.
All I would add is, I don't know the answer either, is I say that I hope that you can speak up without any backlash. I can tell you my personal experience. I'm a lesbian, and when I started my first job out of law school, I didn't tell anyone I worked with. I lived with a roommate. So I know it's a totally different scenario. But I finally did come out, and I felt very safe there. They were very accepting. So I was really lucky. And I ended up choosing a path and a career that allowed me to speak up, without backlash. Working in legal aid, I worked with people who were speaking up. So, maybe I chose the easy path so that I could. And it was a great career. It was really rewarding.
Great. Thank you for that question. Madison, you also had a question. And so for folks who have questions, if you want to be on video, chat me and let me know, and then I can tee you up to ask your question. So thank you both. And Madison?
Hi. I think in some ways my question is probably transitions well from my colleague Shantae's question, which is just pertaining to how y'all as judges consider the current or, changing political atmosphere. And then on top of it now, aside from politics, COVID, how does that inform your work or change your work? Are y'all of the mind that the law is rigid and stagnant and therefore doesn't change with politics, whatever that means, as y'all kind of pointed out? Or do you think that you have like a duty to adapt your rulings to political changes? How do you make those decisions as to, I guess, maybe moving the ball versus maintaining precedent, or using new information that you now have because of the political climate as applied to your work?
I think that the law allows us to rule and think based upon where we are in time and what facts and data are given to us at the time. And the example I would use is the Supreme Court's ruling that we got yesterday. So the law has been the law for decades. And in this climate, and with the arguments and the data that we have, the Supreme Court decided that homosexuals and transgendered people are also protected by the law. So I think that, you know, the way I practice as a judge is I try to have a thorough understanding of the law and any cases that have informed the law. And then I apply the law and I apply the facts and the data to reach my decision. And I think the facts and the data change as life progresses. And I'd like to believe that the law is fairly malleable so that we can apply the facts and data as it approaches us in current time. I also think that laws will change and progress too.
Judge Conlon?
Yeah, another excellent question. Thank you. I mean, I wouldn't say that politics influences what we do. I think that's something that we should avoid as judges. But the political climate is something different. I will say in my current assignment in the Chancery Division, we have a lot of cases that arise in equity, which gives courts latitude to consider lots of different things. It has to be evidence, of course. COVID's a great question because there's plenty of evidence from experts, but it's changing on an almost daily basis, right? As lay people just trying to live in a healthy, safe way, it's so hard to keep up. We have a number of cases involving really interesting, important public issues with nursing homes, jail safety, two of the front lines in the pandemic. And, you know, in terms of do we accommodate sort of change in the times? Of course, because we have public health evidence coming in and experts who are giving us what we need, hopefully, to make a right decision, which honestly could be something that changes in a few weeks as we move through phasing and all of that. So we have to be, I wouldn't characterize my court as nimble. It's not, it's an institution, and it's, you know, it's reactive, and that it should be reactive to what comes in. But some of the evidence and expertise that's coming in, even over the last 3 months, I have seen it change in terms of the advice that's being given and what people are asking me to rely on in order to make certainly the public health related decisions. So we're trying to react in a fair and just way as well as we can. And the change is complicated, but it's good because it's a truly changing world.
Judge Chang, did you hear the question?
I think I got the gist of it, yeah.
Yep.
I think, right, and I think as my colleague said, there is a difference in letting the winds of politics, you know, whichever way they may be blowing, to influence our decisions, because we can't do, versus actually just development of knowledge, you know, whether it's health or you know, other grounds of knowledge where we can then, you know, that might justify a change in a legal principle, because legal principles do apply to facts, and so that could justify a change in course in the law. But just as an example of, you know, no matter what the kind of overall public response is in terms of a legal principle, you know, qualified immunity right now, that is the source of enormous debate, and it has been the source of debate for many years, and indeed, you know, some lower courts of appeals had been consistently every Supreme Court term reversed, you know, per curiam, no oral argument, because the
the Supreme Court thought that they were not enforcing qualified immunity as rigorously as they should. But that's a legal principle. There's a Supreme Court precedent, and I will apply it. That's the way it has to be. If Congress decides to overturn it, and it can, Section 1980, it's a doctrine that is interpreted into Section 1983, and so that's a statute. Congress can overturn it, but until they do, I will apply qualified immunity because that's what the Supreme Court precedent dictates.
Thank you, Madison, for that question. And then we have a question from Caitlin from Legal Aid Chicago, or Legal Aid Society.
Hi. Yeah, so my question is regarding kind of a tricky balance, at least that I found in direct client work, between recognizing the victimization of people who have experienced inaccess to justice and also empowering them to take an active role in their story. So I was wondering if you have any experience from the bench of ways you've kind of ridden that balance or ways you've been able to take an active role in that.
Someone want to jump in first? Judge Schneider?
I think probably the best way that I can empower someone who has had difficulty reaching justice or with access to justice is listening. Most of the self-represented litigants who have appeared before me, they want me to listen. And that's the key. They want to be heard. They want what they perceive, whether it is or isn't, as injustice, to be heard. And the best thing I can do is listen fully, and make sure that I give their requests due time and consideration, and give them a thoughtful outcome. Sometimes the outcome might not be what they want, but I'll tell you, if I've listened and explained, in my ruling, so they understand that I've heard them, I think that there's a high degree of satisfaction with that.
I think not surprising to me that Judge Schneider would be all over this given her prior career and where she's sitting now. I tried to build in some regular procedures. I'm a big believer in checklists, as mundane as this sounds, to just kind of make sure that as I'm going through a busy, high volume call, that I'm treating everybody with some modicum of sameness, which actually I think can be very comforting to people who feel that they have not been treated as equal to others in the past. And I was amazed, especially as a new judge, just to stop and say, "Good morning, Mr. So-and-so," and look at somebody in the eye. I'd say 7 times out of 10, the person would move his or her head back, like be sort of visibly changed or stricken that I would take the time to do that. Or if somebody says, "Good morning, Judge, how you doing?" Instead of blowing by, I'm like, "I'm okay today, how are you?" Helps. I'm not saying that these small things can right past injustices, but I think they can help lay the groundwork for giving somebody comfort that whatever happened before is not as likely to happen here. And sometimes, as Judge Schneider said, you'll listen not just about this case, but by whatever happened in the past that caused somebody to feel disempowered. And I would come to say, "I'm really sorry that happened to you." And at first I thought, I don't know, as a judge, should I be? But something, I think it helps. Not all the time. Sometimes it's not pitch perfect, but it seems like a decent thing to say. And it seems helpful in terms of moving on. And then beyond that, as Judge Schneider said, just giving somebody a chance to be heard in a way that seems fair. Another lesson that I learned is initially I thought, well, I don't think I'll read the law to people when I'm making an oral decision if they're self-represented, because they probably, it's just going to sound like gobbledygook. Well, a judge who's more experienced and smarter than I am taught a course and said, it's not a bad idea to read from a statute, even if it is gobbledygook, and hold it in your hand when you're ruling as a visual symbol that you're applying the same law to everybody, and that it's not a ruling from your heart, which some people say they want, but I think we all want to be kind of on the books with discretion on the side, right? We all want to be held to the same standard. So there are some mechanisms that I think you can put into place that I have found to be successful, not all the time. Sometimes they haven't succeeded, but I have come to be a believer in trying to incorporate those processes.
Yeah, I think it's worth noting too that when you're a lawyer and you're trying to get your client's story out, sometimes you can push that too much in the sense of you try to translate the story into kind of legal and technical terms, and it loses its power in that respect. So, for example, the best allocutions at sentencing that I've heard are just when the defendant speaks from his or her heart, and usually his heart, and it's not something that is memorized in a way, and I understand if a defendant does not have a substantial level of education and so on. I'm not expecting 3 single-spaced pages of eloquence. I just want to hear that he's sorry, why he regrets what he did, what the plan is for the future. And excuse me, and I think lawyers sometimes get in the middle of the allocution and kind of mess it up because they've worked with their clients and then it comes off as not very genuine. Same thing goes for direct testimony. If you're eliciting, for example, emotional distress damages testimony, when you go through the questioning the first time you're practicing it, just let them say it in their own words, first. And then it's your job as a lawyer to break up the questioning, right, and to elicit that emotion, but without trying to make it sound like, that the witness is speaking in legal terms. Like I want compensation. It's like, well, that's not how people talk. And again, I'm not expecting this answer after answer of kind of eloquence. So just be wary of getting kind of too involved in shaping the story. And the last thing is, to the extent that you think juries or judges don't understand this, like they have difficulty putting themselves in your client's shoes, you should note that. Like in closing argument, the defense attorney might get up there and say, let's say in a emotional distress case, and say, what did the witness say about damages? It was like 2 sentences, ladies and gentlemen. I added it up. It was only like 15 words. Well, then in rebuttal, your response is, my client started working, when she was 14 years old. She had to leave school, and made her way up to being a supervisor on the factory floor. And did you expect Shakespeare? So you can just manage those expectations too, so that the juries and judges have empathy for not just your client's story, but how they tell the story.
Thanks, Caitlin. Does anybody else have a question they want to ask? I'm out of questions right now from the chat, but if I'm going to give like 10 seconds for another intern or fellow to join in, or I'll ask my question. Okay. Well, I was kind of curious how the judiciary's impact has been from COVID. And I know we talked a little bit beforehand, just hearing about, Judge Conlon's hearing this morning. But if you all could talk a little bit about the response and how it's been going, doing things over virtually, and kind of access to justice in that concept. Judge Schneider, do you want to start us off?
Sure. I work in the Daly Center, and that building is not ideal when you're talking about a highly transmittable disease. The building is, we accommodate thousands of people in that building every day when, before this all happened. And so, rightfully so, our chief has said we're not going to have the public in there because it's just really dangerous. So it's been a dramatic change for us. The chief's order has continued most civil cases, and they've just been continued now through early July. This has forced judges to use technology to try to achieve the goals of justice. And I think it's a great thing because it absolutely increases access to justice. You know, I work on the Illinois Supreme Court Commission on Access to Justice. I think you mentioned it, Brent, earlier on the Forms Committee. So we draft plain language forms that can be used in all state courts. So they're unified forms, and they have to be accepted in all the courts, the state courts. And the other projects that the Access to Justice Commission works on are how to access the courts for, you know, language access. What do we do if someone needs an interpreter? Or make sure that we have access for disabled people. And this has been a topic we've been talking about, and now we're forced to use technology. So I think it's you know, it's a marvelous improvement. Hasn't been easy to achieve, but in my opinion, I think it's not going to go away. I think that going forward, we'll probably see a combination of in-court appearances and virtual appearances. So I look forward to that.
Judge Conlon?
I agree with Judge Schneider. I think that this has, in a way, the silver lining is it has brought our circuit court to a place with technology that we've wanted to be for a while. I'm encouraged by Zoom. I mean, I've used it in a number of hearings. My first Zoom hearing was on a case that had a lot of public interest, an emergency motion. And when I logged in, there were 44 people in the waiting room. And a lot of them were just interested members of the public, and I could see them on their phones driving in their cars. And this suggested to me a certain like populist participation that I think is really encouraging. On the other hand, I was watching a Zoom hearing by one of my colleagues yesterday that was broadcast on YouTube because so many people called in that they couldn't post it on Zoom. And there was a gentleman testifying, a witness from his home on the South Side, he said, and his internet was not good. And it just created a lot of delays and repeating, and I worry about people's access to sufficient technology because while I know it's, you know, you need a phone at least and you need decent internet, right? And so those are two barriers that we are thinking about and need to keep thinking about. The other biggest concern on my mind is that so many resources for self-represented litigants in the Daly Center are located in the building. And our building is open for very limited purposes right now. And without those bricks and mortar opportunities for interface, I think it's creating, understandably, just a lot more confusion than there already is for people who are representing themselves in getting access to justice. This is creating temporarily more barriers, I think, is just the reality of it. And we need to figure out ways to remove those barriers as we start phasing back in, because those services are so critical. And I really can see in terms of emergency motions that I've received during the hiatus from self-represented people, I think it's very easy to connect that to the lack of physical services in the building that had formerly been available.
Judge Chang, what's your perspective from the federal bench?
Yeah, so the last few months we've not physically been in the courthouse. It's only actually this week that we've started to return to the courthouse in very limited circumstances, and only for those hearings that must be in person by law or by statute, including felony pleas and sentencings. So it is extremely limited. And even those, we're only going forward with those that we think we really need to move forward with. And it is a barrier, I think, also for civil pro se litigants, because we in this court, we did have a culture, I think, more so than other federal districts, of holding in-person status hearings. I think in a lot of districts across the nation, you do everything by paper. And then you might see the district judge maybe at the pretrial when you're setting the discovery scheduling in the very beginning, and then trial. And you don't see that judge in between, but we have this greater culture of access. And of course that redounds to the benefits of pro se litigants, because they're not always able to have the resources or the background or education to put in writing what their needs are. And it's only through talking at the status hearing or motion hearing that we get a sense of, okay, this is what you really need, and then we can move the case forward. But it's so much harder in writing, but unfortunately that is what we've had to move to, is just to get status reports and requests in writing. Hopefully we will expand both our telephone and video conference capability in the next couple of weeks. We've got those services set up, and we've had some of those services in place, but just on much more limited basis, and just because our infrastructure was not completely capable of handling it. And then I do worried about jury trials, and like, when are they going to resume? We're trying for August 3rd, but I don't know. And of course, our priority is detained defendants. That we have defendants who've been in custody for a year, 2 years, even longer. And I just happened to have 4 detained defendant trials lined up from March, April, May, June. All had to be continued. And I'm trying to get these defendants a trial as soon as possible. But the difficulty in seating 12 jurors and sometimes 13 and 14 for alternates, to have a jury selection, with 50 venire persons, it is an extreme challenge. And yet, they're detained. And we released many defendants during the last few months. It's just the ones that we absolutely feel like the statute requires detention now. And that is a struggle and concern.
And could I just add that I see Madison had a follow-up point to her question in the chat, and thinking about Batson challenges and so forth. The jury pool constitution is a big concern too. Look at how it's, for instance, when we do start calling people back in for jury duty, for Judge Chang's trials and others, what happens to the elderly folks? Are they going to be underrepresented or not represented at all? People of color who have been disproportionately affected by COVID. These are also like hot issues that are being discussed as we all try to figure out how to resume services in the fairest way possible.
So with 2 minutes left that we have, can we quickly just go down the line and see if, do you have any final career advice or tips or things to avoid for these soon-to-be attorneys, and maybe in particular with the things that we've talked about today with, the pandemic, the unrest, everything going on in the world. In 1 minute each, if you have any final thoughts. Maybe back to Judge first and then down the line.
I'm sorry, who first?
Well, you're unmuted, so Judge Chang, I'll go to you.
Sorry, I didn't hear that last bit.
No, that's okay.
Yeah, well, I think in today's climate, it is easy to kind of stake out your position and then stick to it no matter what happens. And of course, as a matter of personal principles, that's very important. As a lawyer, it is important to be able to see both sides of an issue. And it's true, not every side is an issue. There are some arguments that are frivolous, and you can call them out as frivolous, but always take a breath before doing that. Because I think the more open-minded you are, you really do try to put yourself in the other person's shoes, the other lawyer, the opposite sides, their shoes, the more effective you are going to be. Because maybe the judge or the jury is going to react a certain way, that you don't anticipate because you were too closed-minded. So it does take affirmative willpower, to try to keep that open mind as you advocate your client's position.
Judge Conlon?
Sure, really good advice there. I would just add that we talked earlier about asking questions, the importance of it. I remember as a young lawyer, sometimes I was too shy to ask questions, or I thought that everybody would know something instead of me. And looking back on it, the easiest time to ask questions is in the beginning. And on my cases, it only became harder later on to ask the questions that I should have asked in the beginning or thought of asking and didn't ask. So take advantage of the newness of situations, ask questions, and I think not only is that good advice for newer lawyers, but under today's circumstances, we have to keep asking ourselves the harder, and each other more importantly, the harder big questions that we've also been touching on today.
Judge Schneider, take us home.
Okay. Well, Brent had put together some questions for us before we met today, and one of them asked about advocacy skills. So it reminded me of a paper that I read a while ago by a Harvard law student who was sort of in search of how to attain advocacy skills. And she summed up advocacy, which I think is being a lawyer this way. She said it's the opportunity to spend a working life applying knowledge and analytical skills in an effort to form meaningful connections with people while simultaneously making a positive contribution to the community. I thought that was beautiful. And then I was trying to think about what important advocacy skills we need to be effective lawyers. And among those were teamwork and problem solving and critical thinking and being innovative and creative. But the one that struck me is self-awareness. And I think that more than ever, I need to be aware of implicit biases and make sure that I try to be aware of what those are. And I think we all can work on self-awareness as a great skill to be better lawyers.
Thank you. Well, thank you three and everyone for this wonderful discussion. Judge Chang, Judge Conlon, Judge Schneider, thank you all. And we'll be here next week for our next session. So thanks everyone.
Okay, it was a pleasure being here. Thank you.
Thank you.